This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
And we are now joined by Todd Lutsky from the law firm of Cushing & Dolan for Ask Todd. This is the segment where... I didn't say you could speak yet.
Oh, yeah, sorry.
This is the segment where you have your chance to ask Todd Lutsky your estate planning questions. And the studio line here is 888-205-2263. So that's the number to call if you want to talk with Todd Lutsky about your estate plan right now. 888-205-2263. Mr. Lutsky, how are you?
Now I'm allowed to talk. Thank you. I'm doing great. You?
I'm struggling a little bit.
Uh-oh. I'm ready.
My wife
Uh-oh.
dropped the laundry basket last night.
I hate when that happens.
She's a little bit upset with me because
Yeah.
I just stood there and I watched it all unfold.
That's good. I do like that. I usually get yelled at when I don't take the laundry basket from the first floor to the second floor and walk right past it. And she says, "Didn't you see it sitting there?"
It's like that episode of Everybody Loves Raymond with
Yeah,
the
the
suitcase
luggage.
on the staircase.
How did you not see
And then
it?
finally he's stuffing cheese into it so it smells and everything. It's a good one. Todd, let's talk a little bit about qualified assets.
Sure.
Your IRAs, other retirement plans, 401ks, 403bs, TSPs, you name it.
Good. Yep, all of those.
If someone wants to protect those from a nursing home, conventional wisdom, the only way to get that into an irrevocable trust is if you pull it out, pay all the taxes, and then maybe you die and now you haven't done anything because you've just paid a bunch of taxes and everything. There's no real easy way to get qualified assets into an irrevocable trust, correct?
And not only is there no easy way to do it, I'd say almost at least at one time, the way you're describing it, Chuck, there's no way to do it. I know let's just put together an example with some numbers.
Go for
it. Let's say we've got a family that has, a home worth $1 million, and they have a 401k of let's say an IRA of $600,000 for husband and $600,000 for wife. Just there's your money, right? Well, obviously we can protect the house. They've got all their money. They saved good in their 401k, and they've now rolled it into an IRA.
Saved well.
And they want to now protect the house, which we certainly can do, and miscellaneous other investments we can certainly protect by putting those into the trust. But it's those darn IRAs. Now, there's two options here, right? One is just leave them there, live on them, spend them down. Let's say the couple's 65 years old.
Mm-hmm.
They're getting started at a great age, by the way, to do planning. If you're 65, it's great age. We're easily going to make the 5 years on protecting the house by getting it into a trust, no problem. But, we can either A, live on those assets and spend them down over the next, say, 20 years or so before we may need long-term care or may not. And that's okay. That's certainly an option for people. Or you could say B, and maybe there's three ways. B, I'll just take one of them, leave one out, leave one $600,000 out, take one $600,000 and stick it into the trust right now. Oh, red flag. If I do that, I got to take 6 times maybe 40% federal and state because I'm in the top bracket, I would think.
By that point.
Yeah, so 6 times 4 that's $240,000. We got to give to the government first.
And then if you die tomorrow, you've done that for no reason.
For no reason. So that's a very good point, Chuck. And the answer is yes, I can't justify doing that. So B is not really an option. But just so people are thinking about it, we now know why not to do it. Okay. Well, another option would be, what we could do is we're young enough that maybe we can take it out slowly. Maybe over the next 5 years, I can take out $100,000 a year. Well, that's not bad. And I'm going to stop because each time I make out the $100,000, yes, I got to pay some taxes on it, but I can stick it in the trust and it creates its own 5-year waiting period. So I'm basically saying at the end of 10 years, I'm going to have my house and maybe $500,000 worth of assets protected. Well, not quite 500 because I had to pay the tax, but I get it. Not a horrible option. Or
Or
the coup de grace
oh,
would be
we're going French.
yes. So it
must be good.
I probably blew that whole thing. But the thing you could do is this new idea under the Secure Act that says we can set up our irrevocable trust, just like I was describing, along with a testamentary trust built into our will, and name the estate of both IRAs, or name the IRA's beneficiaries the estate. And so now if one dies and never goes to the nursing home, which is very possible, and we hope that's the case, that asset on the first death will now, through this arrangement, be not only sheltered for estate taxes, provide access to the surviving spouse, but also overnight, with no 5-year waiting period, protected from the nursing home in the event the surviving spouse gets sick and goes into a nursing home anytime after the first spouse dies.
Talking with Todd Lutsky, estate planning attorney from the law firm of Cushing & Dole. And the segment is called Ask Todd because it's your chance to ask Todd your questions. Right after this next break, we're going to your questions. So call 888-205-2263. That's our studio number, so you can talk to Todd Lutsky right now on air. The number again is 888-205-2263 for your chance to talk with Todd Lutsky now. One last time, it's 888-205-2263. Quick break, then right to your calls.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network.
As promised, we're going to go right to your calls with Todd Lutsky. First up, we've got Sue in the car. What's your question for Todd?
Hi, Todd. I'm a widow, a 63-year-old widow. I have $250,000 in a 401k. Actually, in 2023. Is there any way when I have to start taking out the minimum distribution, I have to take it out soon because it was my husband's, not mine.
Okay.
Is there any way I could pull it out and then invest it? I don't want to need it. I want to leave it to my son. I have long-term care insurance. I own a house, and I own a rental property.
Yeah, so it sounds to me like you have a lot of other assets as well. So don't focus just on the 401k, right? So I would say your house, your rental property, some of your other assets we should absolutely focus on, if it's something you want to do, protecting these assets from the cost of, perhaps long-term care, avoiding probate, and figuring out the most efficient way to get these assets to your family. That said, your 401k, unfortunately, you are going to have to take it out. Everybody does when you reach a certain age. If it's an IRA at 72, I don't know about how it happened with your husband's rollover, but it will have to come out. When it comes out, it will have to be taxed. There's no way around it. And once you pay the tax, yes, you can invest it any way you want to invest it. And you can put it into the trust. The only downside with putting it into an irrevocable trust is that it creates a new 5-year waiting period for the nursing home. So it may be that we focus, and I don't know enough about your estate, but it may be that we focused on assets that we can protect and maybe focus on spending some of those qualified plan assets that you are going to be taking out. So hope that helps a little bit. And you know what? The question is actually spot on because that's what we're talking about in our guide today. IRAs and life insurance are problematic assets for estate tax planning and nursing home protection planning, as we just found out from this last caller, right? That's exactly what we're talking about. This guide is going to show you how best to handle an IRA and a life insurance policy from estate tax planning and nursing home protection planning, something we could never do before. We now have an opportunity to do. My advice is call, get the guide. It's the pros and cons of naming your estate an IRA beneficiary. 866-848-5699 or legalexchangeshow.com. You can download the guide right there. Again, the number is 866-848-5699 or legalexchangeshow.com.
Todd, let's go now to Sam in Vermont. Sam, you are on with Todd Lutsky.
Hi. I have a question about I have a revocable trust, and I'm interested. I was thinking about maybe about a generation skipping trust.
You said your trust is irrevocable?
No, revocable.
I'm sorry. Okay, revocable. Yep, go ahead.
I would just like some enlightenment about a generation skipping trust.
So the answer is, how much are you worth in total, and are you married?
Probably $2 million.
And are you married?
No.
All right, so with $2 million of assets, can you put them in a trust? Yes. The revocable trust will avoid probate, and since you're single, it will not do anything to reduce estate taxes, not that you really have a big estate tax problem, which is the first tax we need to consider. Federally, it's none. Massachusetts, it's a little, but remember, only a little, because hopefully they'll end up passing the legislation that's pending to maybe make it $2 million as an exemption for us here in Mass. The question is how you leave it in the trust. If the trust just pays out to your children, then it's not generation skipping, and they'll get it. Well, if you want it to be generation skipping, then you need to put language in the trust that says we're going to hold everything in trust and allow the trustee to make sole discretionary distributions of both income and principal to the children of all generations. That's including grandchildren. And now this way, unless it actually comes out, it's not going to be included in the estate of the children when they die, unless, of course, they've depleted it all. And the way we have it set up is it can then be held in trust tax-free down to the grandchildren. There's your generation skipping tax component. And when they die, you can have it set up against the rule against perpetuities where it ultimately can be used by them. And if they don't deplete it all, then when they die, it wouldn't be included in their estate and ultimately will pass to great-grandchildren, at which point it will have to come out over the next 20 years. So not bad. That's triple generation skipping benefits and can easily be done in your case.
Todd, we got one more quick one for you. Let's go to Andrea in Weymouth. Andrea, you're on with Todd Lutsky.
Good morning, everyone. Happy holidays. Todd, my husband and I have trust that you did for us.
Okay.
And I have this running thing going on with my financial advisor.
Mm-hmm.
Our 401k money is obviously it's not in the trust.
Good.
We take the interest because we need it to add to our Social Security to live.
Perfect.
So here's the problem. So we have that amount of money that is, I guess you'd say, at risk.
Yep.
And when I went to the financial planner and said, but Todd, Todd's saying she was saying, not.
Try to just ask the question.
Okay.
We're running out of time.
I'm confused about where can the money go. She's telling me one thing and your office is telling me another thing. How do we protect the 401k?
Well, again, a 401k, likely I would say if you're not working, I would roll it out into an IRA. You get more investment options. Again, I'm not an investment guy, but I think you have more options. And then, how old are you?
It's an IRA, 69 and 72.
69 and 72. So, perhaps one thing you can do is we can set up these new things that I'm talking about in this guide for the 72-year-old. That works perfectly by naming the estate the beneficiary. But between now and then, if you've got more assets already protected in the trust, just live on those assets. Take them out, spend them how you want, and live on them. And/or we can set up this new testamentary trust idea as a way of at least protecting some of the assets in advance. So a phone call to the office on this one might be helpful as we are running out of time. But thanks very much for the call.
Todd Lutsky, thanks for joining us today.
Always a pleasure.
The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated.